Welcome once again to Lehto's Law. Here's Steve Lehto.
A friend of mine and a very good friend of the show is named Chris, and he and I have had a couple of spirited and heated discussions about whether or not it should be unconstitutional for police officers to simply scan license plates at random with license plate readers and, in essence, do checks on license plates just out in public. And he and I have discussed this, and I said, well, you have to understand that on some level, they say, well, how obtrusive is that? Your license plate's available to the public. It's out there, and so if I can look at it, why can't I scan it? And he says, well, of course, Steve, the scanning is more than them just looking at it, because they scan it, they check a bunch of information, who knows what else they might do with that information. And so it's an interesting topic. And I said, well, it's going to take courts to settle this. So Rick sent me a note today, and Rick knows nothing about my conversations with Chris. That's just a side note. And Rick said, Steve, there's a fascinating case that just came out of a Virginia trial court. Okay, so this is not like an appellate court or anything like that. This is not a circuit court of the U.S. Circuit, Court of Appeals or anything like that. It's the Fourth Judicial Circuit of Virginia, Circuit Court of the City of Norfolk. Okay, and that's in Virginia. And this opinion just came down, I think, last week. And Rick sent it. I've got the whole PDF here. It's 5 pages long. It's a case called the Commonwealth of Virginia versus Bell, B-E-L-L. Order granting defendant's motion to suppress. So the court here agrees with my friend and is saying, hey, you got to take a look at what these readers do. They don't just read license plates, at least not this one. So the matter comes before the court on the defendant's motion to suppress pursuant to the 4th and 14th Amendments, the U.S. Constitution, as well as the Constitution of Virginia, the Code of Virginia, and specifically, the defendant moves the court to suppress the photographs of the vehicle the defendant was driving from the Flock automated license plate reader system. And so then, after he got pulled over, he made some statements. They wanted to use those statements against him. And so they're saying all of that flowed from this search done by this Flock automated license plate reader. Now, here's the thing. This wasn't just reading license plates. It was also photographing cars and recording where they were. And that's a little bit more than the typical just reader. But the Commonwealth charged the defendant with one count of robbery by using or displaying a firearm in violation of the law, plus a count of using a firearm in the commission of a felony, and a count of conspiracy to commit robbery. So a suppression hearing was held back in April in the circuit court. According to the defendant's motion, and not contested by the Commonwealth, the police department installed 172 license plate camera readers throughout the city in 2023. A whole article about that in a local paper. The cameras are able to track the locations of vehicles within city limits by license plate number and other physical descriptions, with the data being kept for 30 days. Every officer from the police department may access the Flock system, which shares its data with other police departments. An investigator testified on direct examination generally about how the system worked and stated that a suspect vehicle in a robbery in the neighboring jurisdiction of Chesapeake was recorded on the local Flock system. He said that Flock is no different from the red light camera system that they already utilized, and they have utilized for years, although Flock is a much newer system. He described it as a real-time intelligence to combat crime. He further stated that all of the Hampton Roads police departments have Flock systems, and police departments can share information within the systems from neighboring jurisdictions. No special training is needed, and all the officers in the police department have access to the Flock system. The investigator claimed that Flock does not provide any personal information about the owner of a vehicle, but the license plate information only. But the cameras are motion activated, they photograph the car, and of course they note the location. So he testified there was a robbery in Chesapeake, and an independent witness provided a license plate number to Chesapeake police. More specifically, the detective from Chesapeake issued to this man that the witness described a gray Dodge minivan leaving the video game store, and the police department was able to stop this minivan on South Military Highway after using Flock. Investigators stated that after communication with the Chesapeake detective, he ran the vehicle through the Flock system and discovered a hit with a Dodge minivan alleged to be used in that robbery. He testified that a robbery of a video game store occurred in Norfolk recently after the one committed in Chesapeake. There's an additional description of 2 individuals who left the Chesapeake robbery in the minivan. The Commonwealth's attorney asked the investigator if he'd gotten a search warrant for the Flock system, and he emphatically replied he did not need one. And see, that's a great example of they ask a question and they answer a question they weren't asked. Did you get a warrant? I didn't need one. Okay, is that a no? I assume that's a no. Okay, we can ask it again. Did you get a warrant? I didn't need one. Okay, did you get one? Because you didn't need it, or because you didn't need one, you didn't get one? Because the answer to the question is simply no, you did not get a warrant. He believed the minivan in question that the defendant was arrested from during interrogation, provided an incriminating statement, was used in a video game store robbery in Chesapeake, Norfolk, and Portsmouth within a short time frame. On cross, the investigator stated he used the license plate information from the Flock system to access a DMV database and learned that it was linked to the defendant's wife. On redirect, he said he did not know how many red light cameras were located within the city limits, but there were 172 Flock cameras installed. So to analyze the case, the court says the Fourth Amendment safeguards the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and no warrants shall issue but upon probable cause. So we talk about this, and the Bill of Rights has a whole list of things you're entitled to. And it does not say, by the way, if the police violate this, what they find will be excluded. The exclusionary rule was developed by the courts because they said, well, without some kind of remedy, it becomes meaningless. So you've got to have something in place to where they've got to play by the rules. So here the court finds the collection and storage of license plate and location information by the Flock system constitutes a search within the meaning of the Fourth Amendment and should require a warrant. So make sure you understand that. This was a search. The defendant argues that vehicles in the current technology age are akin to cell phones, and the court agrees. And you might say, wait. Who cares if your car is like a cell phone? Well, courts have already determined that the government's acquisition of a defendant's historical cell site location from wireless carriers is a search under the Fourth Amendment. In such cases, a warrant is required except in extreme circumstances. Furthermore, the court found that an individual maintains a legitimate expectation of privacy in the record of his or her physical movements as captured through cell site information. Now, the Commonwealth argues that vehicles are different because the defendant did not have a privacy expectation in the public sphere. However, a person does not surrender all Fourth Amendment protection by venturing into the public sphere. To the contrary, what one seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Individuals have a reasonable expectation of privacy in the whole of their physical movements. The Flock system collects and records a vehicle's movement data in the same manner as the cell towers get your data. And the point here is a simple license plate reader that's attached to a police car, like say driving through a parking lot. And it's reading license plates and all of a sudden it goes ping, expired plate, or ping, suspended driver. That's not as much information as the Flock system's gathering. This network of cameras, if you drive through town, records your vehicle at every single one of these locations where you pass one of the 172 cameras. So that's a lot more than simply your forward-facing license plate, okay? So like obtaining and storing of cell site location data, installing a GPS system on a vehicle to track a citizen's whereabouts likewise requires a warrant. And that's a U.S. Supreme Court case. Now, the Fourth Circuit rejected an aerial surveillance program with data storage because it permitted law enforcement to deduce from the whole individual's movements. We hold that accessing its data is a search, and its warrantless operation violates the Fourth Amendment. So again, that's another case talking about a different kind of search. Moreover, the court cannot overlook the foundational issue of this type of system. And they point out that if somebody wants to introduce a 911 call into evidence, they often bring in the 911 operator who took the call. But here, you can't exactly cross-examine one of these license plate readers now, can you? So that's a foundational issue that the judge had here. The court emphasizes that it's perhaps most concerning for the local police department to make warrantless use of the Flock system, about which the courts of the Commonwealth know so little, is due in part to the many ways in which it could be abused. Modern technology enables governments to acquire information on the population on an unprecedented scale. National, state, and local governments can use that information for a variety of administrative purposes and to help apprehend dangerous criminals, but knowledge is power, and power can be abused. And that's a case called Neal versus Fairfax from 2020. Unlike in other jurisdictions where special training is required in order for law enforcement officers to access these kinds of systems, the local police department does not require such training, and all officers have unfettered access to the license plate and location data stored for 30 days. So the Commonwealth argued a bunch of things, including Katz versus U.S., saying, hey, look, if you're in public, you lose all privacy. It's not really what the case said, and this court shoots that down. The Commonwealth also argued from Commonwealth versus McCarthy, a case from the Supreme Court of Massachusetts. In it, the court concluded the defendant's expectation of privacy was not invaded because there were only 4 cameras on the ends of 2 bridges recording license plates with ALPRs, and such surveillance was limited and not indicative of the Fourth Amendment. This is not the case in Norfolk. And by the way, are those cameras there to spy on you, or are they there to record your license plate and send you a bill? Because I know a lot of bridges have got those too. Finally, the court rejects the Commonwealth's contention that without the flock evidence, this would be a matter of inevitable discovery. And so if the police do something wrong without a warrant and they get busted for it, in essence, they can always make the argument, well, we would have found it anyway. But that takes extreme facts to get there, and the court said no. Here the court is unconvinced they would have discovered the defendant in the suspect vehicle in a way to immediately arrest him before obtaining the incriminating statement without the flock system. So the defendant's motion to suppress is granted, and the Commonwealth's objection is noted for the record. The clerk is directed to mail a copy of his order to counsel of record, and it's signed by the judge. Now, interestingly, Rick sent me a note after he sent me the story and said, by the way, Steve, my understanding is that they're not going to appeal this. Which might not strike you immediately as interesting as I find it. But of course, see, the court just ruled in favor of a defendant on the legality of that flock system. But it happened at a trial court level. So that means it's not binding precedent, except pretty much in this court. However, if it goes up on appeal, and an appellate court hears the case, and if they rule, their ruling then becomes the law in that circuit, depending on how it works, or in Michigan, where the circuits aren't divided like that, it would be the law in the entire state, unless changed by an even higher court. So when you don't take a case up on appeal, it often means that you know you'd lose on appeal. Now, don't get me wrong. I'm not talking about lawsuits here. I'm talking about when the defense moves to exclude evidence on a novel concept, because the court also said this is a case of first impression. They've never ruled on this before. So they rule on it. If the prosecution opts not to take it up on appeal, it's because there's a high likelihood that they think they're going to lose on appeal and make bad law. So as it is right now, it appears that we've got one court that said this flock system that's just scraping data from everywhere, of every vehicle that passes by, and recording it for 30 days is a little bit over the top. Now, they didn't say that they have to remove the system. They just said you can't use information from that system without getting a warrant. And I get that distinction. So getting back to my friend who says, Steve, the automated license plate readers that just pick up, trolling for data in parking lots, I think that's wrong. I think it's an unreasonable search. And I see the argument, but that's less intrusive than this. Because like I said, it's possible you could drive through town and ping 25 of these cameras. And they could say, oh, let's see where this person drove yesterday. Let's see where they drove 29 days ago. And that is intrusive. Now, the fact that they're gathering all that information is one thing. What they're going to do with it is another. Don't get me wrong, if the system is there and there's some heinous crime that got committed and they go, we think we can solve it through the use of this flock system, they can go to a judge, get a warrant, and then use it that way. Not a problem. But see, the police don't want to waste their time with paperwork. That paperwork can be pesky. You're driving around your car all day long and you go inside, you got to sit at a desk and fill out paperwork? I mean, that's death in any TV show. You know that. You're watching Starsky and Hutch. When they get assigned to desk duty, they got in trouble. Huggy Bear gave them some bad information. So, right now, this is not like statewide in Virginia, nor is it statewide anyplace else. But the rationale and the explanation, I think, is quite good. So any city that installs these big brother type systems to hoover up all this data have got to be careful, because they may have been able to get these guys without it. May have. But because of this, I suspect these guys are walking. So there you go, Rick. Thanks for sending it. Thanks for all the great notes and so on. Virginia, Commonwealth of versus Bell, and a court has said that all that information being gathered by those traffic cameras can't necessarily be used without a warrant. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Laughter is the best medicine. Unless you're diabetic, then insulin comes pretty high on the list.